All rise. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this Honorable Court.
Good morning. I want to welcome you to the Tennessee Court of Appeals. Madam Clerk, are there any preliminary matters this morning?
No, Your Honors.
And I assume everybody has already reserved their time.
Not yet. No,
Okay.
no, Your Honors.
Okay, then we'll do it on a case-by-case basis. Will you call the first case, please?
The state of Stacey, Sane versus Debra, Sane.
Here for the appellee, Your Honor. The appellant.
And for the appellant, you will start first, but will you reserve, do you want to reserve any time for rebuttal?
Yes, Your Honor. I would ask for 3 minutes for rebuttal.
Okay, so be it. And if there's nothing further, you may proceed.
Good morning, Your Honors. My name is Jeff Green. I'm a member of the Clark County Bar Association. Here on the case of Debra Sane versus Paula Smith Sane. Your Honors, this case is in regards to elective share. More importantly, as to the timeline for electing to take elective share. And what occurred in this case here is that my client, Miss Debra Sane, lost her husband. After she lost her husband, her and her mother-in-law met and discussed whether or not there was a will in this case. My client married her husband in 2016. In 2003, Mr. Sane had prepared a will prior to their marriage. When he was 35 years old, Mr. Sane had a stroke. Was not completely disabled, but was partially disabled from that stroke. Him and Miss Sane married in 2016. He passed away in February of 2020. After that, Debra Sane, which is my client, and everyone's named Miss Sane in this case. So Miss Debra Sane met with her mother-in-law afterwards, made funeral arrangements. The mother-in-law, Miss Paula Sane, told her that an old will existed, but that she was not going to probate it. Your Honors, I believe this was her application. In order to discover what's going on in an estate and what's required under the elective share statutes, the surviving spouse must make application to the personal representative. And as the judge laid out here, there was no personal representative. There was no personal representative in this case for a period of up to 1 year. But during their initial meeting, they discussed the will, and Petitioner Debra Sane testified that she met with Paula Sane and was led to believe that there was not going to be a probate estate for Stacey Sane. The petitioner then testified that she believed Paula Sane because she wanted us to be family and she thought everything would be okay.
Excuse me for interrupting, counsel. Did your client see a copy of that will during that meeting or any other meetings?
I believe she did see a copy of it during that meeting, Your Honor.
When was that meeting in relation to the passing of her husband?
It would have been approximately 4 months after her passing, because I think the testimony shows that she would have had 5 months left to have made her election against the will on that.
Thank you.
During that,
Since we're interrupting, let me ask you about that conversation. Isn't there a dispute about exactly what was said? Because I know you said that the mom said, I'm not going to probate the will, but didn't the mom also explain, at least her testimony was, explain to her what the will contained, that everything was supposed to go to the decedent's son, and asked your client, are you going to quit claim the house?
yes, Your Honor, I do believe that is in the record here. But the mother-in-law that's also in the record, she also told her that she wasn't going to file the will. So that, I believe, is where the fraud occurred. that because she told her, I'm not going to do something, and that under Pritchard's, it says such disclosure is mandatory and must be strictly complied with. Otherwise, the statutory time for filing a dissent will not bar the spouse from making the election to take an elective share. We believe that her conversation in which she told her, yes, there is a will, but we don't intend to probate it, was her application and her notice that the will was not going to be presented. The will was not presented until 2 days before 1 year had expired or had passed from Mr. Sane's passing. During that time period.
Wait a minute, let me make sure I got this right now. Are you saying that, that as a result of that meeting with the mother-in-law, that would be considered the wife's application?
Your Honor, I have no other way to take it because there was no personal representative ever appointed. And the judge laid out in his findings that he was concerned about that, how to match the two. There's no indication here that Debra Sane made application. The other problem, this is quoting the judge, Your Honors. The other problem, though, is there wasn't any personal representative to make application to until February 10th, 2021. There wasn't one because no one qualified at all. So little bit of a confusing area between how do we construe 31-4-103 together with 31-4-102. I confess that. So that was the judge's statement regarding how to reconcile these two issues together.
If she made application, was there a specific request then?
No, Your Honor, and it was not in writing. And again, there was no personal representative. Ms. Paula Sane turned out to be the personal representative once the will was filed almost a year later. But during this time period is when she had told her she wasn't going to file. She sat on it until afterwards. And part of the problem here is that public policy for the state of Tennessee is that you can't disinherit your spouse. I went through Pritchard's again, went through other case law again, and it always comes back to the same public policy of you can't disinherit a spouse.
But a spouse has an obligation to make a claim, make application for their portion, does they not?
Under the statute, they do, Your Honor. So that's where I go back to confusion. If there is no personal representative, then who does that spouse make application to? The court has said that the spouse has a right to go ahead and open up an intestate estate and file for elective share. But that's against the spouse's best interest. In this case, under elective share, Ms. Debra Sane only receives 20%. Under an intestate estate, which was what she was attempting to open, she receives 50%. It would not make sense for her to open an intestate estate in which she's entitled to 50% and then file for elective share against a will she doesn't know exists or doesn't believe is going to be probated and reduce her share from 50 to 20%. So she doesn't have all the facts in front of her at the time that she would have to make that decision. The will has never been filed. The old statute stated within 9 months or 6 months of the filing of a probate. That the statute no longer has or within 6 months of filing of a probate. It is just a 9-month deadline. If you don't act, then the surviving spouse loses. This allows anyone to sit on a will for 9 months. If you don't know it exists, how are you to meet the requirements of this statute? If you are told in a face-to-face meeting, the testimony verifies this, I am not going to probate this will. Then, when you don't do what I tell you, now I'm going to probate this will. That, Your Honor, seems to be fraudulent to me. If Miss Debra Sane had no idea this will was going to be probated, how could she act upon her rights? Once the will was probated, the timeline for her to file an objection had passed. So she had no ability to object to the filing of this will at that point. Also under Pritchard, Your Honor, it says that the court may relieve a surviving spouse from the consequences of failing to make a timely election when the spouse was prevented from doing so by fraud of the personal representative or those interested in the estate. But even fraud to be relieved against must be operative and injurious. In this case, my client lost her house. This was the house her and her husband had shared since the time they were married. It was only in the surviving, or in the decedent's name. Therefore, the surviving spouse had no interest in this house other than an intestate share. I don't know what could be more operative and injurious than to be actually kicked out of your house after your spouse passes away. Again, we believe that because of that fraudulent activity, the timeline should have been extended, giving her at least the 6 months after the filing of the estate to file for her elective share. She filed immediately. There was no delay. There was not, and I don't know the exact time frame, but within less than 30 days of the filing of the estate, Miss Debra Sane filed for her elective share in this case. And therefore, I believe that fraud was perpetrated upon her by her mother-in-law. Another point of fact in here is to just show the mother-in-law's vendetta was after she refused to sign this quitclaim deed, the mother-in-law actually went to the cemetery, had the headstone removed, and had Miss Debra Sane removed from her spouse's headstone. She wanted to be in control, and when my client stood up to her, she presented the will, kicked her out of her house, took her vehicle away from her, and that's how my client ended this case, by losing her husband, her house, and her vehicle all at one time due to the fraud perpetrated by Ms. Paula Sane and the change in 2007 of this statute to no longer allow the surviving spouse a time frame in which to file for elective share after the presentment of a will.
Was the request for a quitclaim deed at the same time as the presentment of a copy of the will?
I believe it was, Your Honor, but I'm not 100% sure. I know that there were multiple requests from Ms. Paula Sane to Ms. Debra Sane to sign this quitclaim deed.
Multiple requests over a period of time?
Over a period of time, yes. I think there were either 3 or 4 requests is what the the transcript would show over that time frame before Ms. Sane, Paula Sane, presented the will for probate.
Were all of those requests made before the running of the 9 months?
No, I do not believe so, Your Honor. But the first one was.
Thank you.
Thank you.
You have your rebuttal time.
Thank you.
May it please the court, I'm Ben Hooper from Cocke County as well. Thank you for hearing us today. I represent the estate by and through Ms. Paula Sane, the mother of Stacey Sane, the decedent, and Ms. Paula Sane, of course, also qualified eventually as personal representative of the estate. This is just a statute of limitations case. There's nothing magic about it at all, and Mr. Green has an unenviable position of trying to put the genie back in the bottle, and the only way to do that, frankly, is to suggest that Debra Sane was somehow misled regarding the nature of the estate so that she did not timely file her petition. In fact, the issue of fraud was the only issue heard and considered by the chancellor. Otherwise, I submit to the court that this case would have been summarily dismissed on the statute. But The 314103, which deals with the application for information, that's speaking to disclosure of the assets of the estate. And although when these meetings between Debra Sane and Paula Sane took place, Paula Sane had not yet been appointed as personal representative, there was full disclosure. Debra Sane lived in the home that was owned by her husband, Stacey Sane. That home contained all of his personal belongings, including his firearms, by the way, which were something that was important to Miss Paula Sane. And I believe what the testimony actually shows is that their first meeting probably happened in March, within a month after Mr. Sane was buried. And at that meeting, in Miss Paula Sane's home, she showed Debra Sane the will. Debra Sane understood that that will left the entire estate to Clinton Hunter Sane, the son of the decedent. And in an effort to avoid probate, Miss Paula Sane said, I need you to sign a quitclaim deed for the home, and I want you to return my son's guns to us so that Clinton can have them. Of course, as you've already heard, Debra Sane refused to do that. On June the 3rd, which again is well within the 9-month period, Paula Sane takes insurance, life insurance money that she and her husband received as the named beneficiaries, and gave Debra Sane a check for $51,414, wrote on the memo line, estate. Debra Sane cashed that check that same day and then subsequently refused to sign the quitclaim deed. Not only that, but something that you haven't yet heard this morning is that Debra Sane went to
in the record first, well.
I'm sorry?
Is it in the record?
Yes.
Okay.
Absolutely. Debra Sane went to the courthouse in Newport, Cott County, and presented a false affidavit of inheritance, which stated that it was an intestate estate, that she was the sole intestate heir, which was absolutely false. And in doing that, caused the title to Mr. Sane's truck to be transferred to her. So the irony here in all of this is that the only fraud in this case was that of Debra Sane.
Excuse me for interrupting, when did that occur?
I think that, Your Honor, happened in July, still within the 9-month period, and again, after she had already received the $51,000 check. So once Paula Sane realized that Debra Sane was not going to do what was necessary to avoid a probate, she opened a probate.
Why did she take so long?
Can't really answer that. You know, she's got a husband, and this is in the record, she's got a husband who's sickly and had, you know, life going on, but that really is irrelevant, Your Honor, frankly, because this statute says that the surviving spouse has got to take action within 9 months. And if the issue is failure to disclose, that's a non-issue. She knew everything. She knew what the will said. She knew what her husband owned. And she also knew that she was the recipient of a $51,000 gift that she was not otherwise legally entitled to receive. You know, frank, that she wanted her cake and eat it too. And, you know, it's the chancellor properly found, number one, there was no application made under 314103 for information about the estate. Of course, that's irrelevant because she knew everything anyway. She lived in the primary asset of the estate, which was the house. She had possession of the guns and the personal effects. And then she, of course, had possession of the truck, which she fraudulently transferred over into her own name. So this case was properly decided based on the statute of limitations, which is a strict statute, and there is absolutely no indicia or even or evidence of fraud that would justify tolling the statute. Thank you.
Thank you, sir. Yes, sir.
Your Honor, as to the life insurance proceeds that were mentioned, in my brief, it is stated in the estate of Ladd that the court held that insurance proceeds are not part of the estate and are not subject to the decedent's will. That's a red herring here. That is not a part of her elective share, would not have been a part of her elective share, and should have been excluded from any elective share. Now, it was not life insurance proceeds to Miss Debra Sane. It was life insurance proceeds to Miss Paula Sane. And in the record, it talks about the fact that Miss Paula Sane kept the life insurance records and the will. Debra Sane did not have a copy of it, and while Stacey Sane was still alive, he did not have a copy of the life insurance papers or his own original will. His mother had both of those. She had those in his possession. During the time they were married, Mr. Sane could not have revoked his will. His mother had it. He could not change his beneficiary on his life insurance. His mother had those. As to the truck title, it is exactly as Mr. Hooper said. She filed the affidavit believing that the truck should go to her. She did not do it to defraud anyone. The truck was maintained, insurance was maintained on the truck, and after the court proceedings, the title was transferred over to Mr. Clinton Sane, and Miss Sane had done no damage or harm to this vehicle. And I think I've laid out there that the home did not contain the will. Mr. Sane did not have an opportunity to revoke this will or change this will, one, due to his stroke condition, and two, because his mother had his will and would not provide it back to him or his spouse.
Well, there's no evidence in the record that he wanted to change it or revoke it, or that he attempted to and it was not provided, correct?
There is not, Your Honor. It's just that it was in all of these papers were in the possession of his mother, and it is in the record that she did not give them those back. Thank you, Your Honors.
Thank you. If there's nothing further, your case has been submitted to the Court of Appeals. You should receive our opinion within a reasonable period of time. I want to thank you both for your presentation here, and we will duly consider this matter. Thank you.